Good day and welcome to our Achieving Respect at Work webinar for Stragies clients. Presenting today will be myself, Steve Champion. I'm the Director at Stragies, and also Georgia Croxen, who's a Senior Consultant with Stragies. These changes we'll be talking about today were originally prompted by the release of the Australian Human Rights Commission report issued by the Sex Discrimination Commissioner, Kate Jenkins. We'll talk about Kate's report and recommendations, some of which have been adopted by the federal government. We'll also provide a summary of changes to the Fair Work Act and regulations, to the Sex Discrimination Act and to the Australian Human Rights Commission Act. And we'll finish up with some suggested employer actions and solutions to the whole issue of sexual harassment and sexual discrimination at work. Over to you, Georgia, to talk about the report.
Steve. So just as Mary touched on at the beginning of this webinar, I think we all are asking the question, why are we talking about these changes? Where did they come from? And more importantly, why are we suddenly talking about them now? And whilst there's been a lot of change, I guess, in public pressure relating to sexual harassment, we've heard a lot about it in the media over the past couple of years. This didn't come from nowhere. It originally stemmed from the Australian Human Rights Commission's 2018 national survey into workplace sexual harassment. And the results were quite difficult to read. It did show that there were a third of people in the workforce within the previous 5 years prior to the survey that had experienced some form of workplace sexual harassment within their workplaces, which is quite a significant number. And when we break this down, it's almost 40% of women and over a quarter of men that have experienced sexual harassment in the workplace. And we're seeing non-traditional forms of harassment being reported as well, including a rise in male harassment of other males. So it is a really important issue that we talk about more broadly across all workplaces. These figures are greatly exacerbated when we look at minority communities, especially around Aboriginal and Torres Strait Islander people, backgrounds as well. So it's really important that we take a public interest in this and a personal interest in this within our workplaces, because it does impact people that we work with every day. And the figures show that we really need to draw attention to it now. The Australian Human Rights Commission noted that victims of harassment can be profoundly impacted by their experiences, and this extends to emotional, physical, psychological, and financial harm. So it's really important that we do combat it in the ways that we can. As a result of the survey, the Federal Sex Discrimination Commissioner, Kate Jenkins, initiated an inquiry into sexual harassment. And this was entitled the Respect at Work report. Her report was released in 2020, and overall there were 55 recommendations that were made, of which 12 were suggested legislative changes. However, only 6 have been implemented by the changes that we cover in this presentation. Of the 6 changes that we're going to discuss, rather than increase employer obligations and responsibilities, these changes are more about clarifying and expanding the operation of existing laws. And we'll take you through these changes now. Over to you, Steve.
Right, and I did allude before that to the fact that there wasn't a specific new positive onus on employers imposed by changes to the legislation as part of these changes. But on the other hand, the federal government has said, well, safety legislation already requires a harassment-free workplace. So therefore, there is an existing positive obligation on employers that comes from that safety legislation. And just to go over that safety obligation, because we have generally the same sort of safety legislation across the country, from most states anyway, that the obligation falls on what's called the PCBU, the person conducting a business or undertaking, which is a lot of jargon. Basically, it's business or the employer, and whether or not they're for profit or gain. So safety legislation covers charities and a lot of other organisations that might not be covered by other pieces of legislation like the Fair Work Act or the Sex Discrimination Act. And safety legislation has a very broad coverage of workers. It basically, the legislation in fact covers anyone coming in contact with a business or the operations of a business affected by workplace health and safety legislation, including members of the public. It is quite a broad duty of care that's owed. And just to spell that duty of care out, the PCBU, which is basically the employer, must ensure, so as far as reasonably practicable, the provision and maintenance of a work environment without risks to health and safety. So as Georgia mentioned before, if somebody is harassed, it can have quite significant impacts on somebody's welfare and their health. So there's an existing positive onus that already exists. And that's what the federal government hung its hat on and said, well, we don't need to put another one in because it already exists under safety legislation. Just to go over what that means in terms of an obligation on the employer, basically you have to achieve that duty of care, or you satisfy that duty of care by risk management. And risk management means you're identifying hazards to health and safety in the workplace. You're assessing the hazards in your workplace. You're controlling or minimizing them, and you're reviewing the whole thing on an ongoing basis. So that's what risk management is. And the government is saying, well, look, you already have an obligation to ensure the health and safety of people at work. That means that people shouldn't be harassed, because if they are being harassed, whether it's sexual harassment, sex discrimination, or all other forms of harassment, well, then that is a safety issue that the employer needs to be doing something about. If we're going to be looking at safety legislation, there's a whole lot of other duties that comes from that the employer needs to be consulting with employees whilst it's doing these things, whilst it's managing risks, identifying, assessing, controlling, and reviewing things on an ongoing basis. So consultation with employees about matters such as harassment is important. Another obligation, so the safety legislation talks about officers, which basically are people in charge. It's boards, it's management. Those people, those officers must exercise what's called due diligence. And due diligence means that they have an obligation to keep up to date on knowledge about work health and safety matters, including harassment. They need to understand the nature of their business operations and the hazards and risks that are associated with these operations. So that's a whole lot of words around safety. And if you're aware of safety and have dealt with it, you'll be aware of perhaps a lot of that terminology. If not, well, then maybe it's you need to upskill yourself on it. We actually have some modules that two modules where we cover safety obligations and how to meet those obligations. So all those things apply to harassment in your workforce or in your workplace in all its forms. There's other duties as well, not only on the employer, but also on employees or workers, that they have a duty to take reasonable care, not to adversely affect the health and safety of other people in the workplace. So if they're harassing others, well, then they're breaching their obligations under the Act and they could be prosecuted. They have to comply with reasonable instructions by management, and they have to cooperate with reasonable health and safety policies that are notified to them as workers. So there is a lot of power under safety legislation that we perhaps don't always think of harassment as the first thing that is going to be covered by safety legislation. Now, we don't want to turn this into a session on safety, just for, to get away from, we don't want to get away from the key issues here, which are some of the changes in legislation. But there is that existing obligation on employers to stamp out all forms of harassment in the workplace under safety legislation. You can be fined for breaching these duties under the safety legislation. Might be a little bit harder under, say, the Sex Discrimination Act or the Australian Human Resource Commission Act, sorry, Australian Human Rights Commission, sorry, unless you breach something under those specific pieces of legislation. But certainly, you can be fined for breaching the safety legislation. But I guess there's a matter of principle here that treating forms of sex discrimination as a safety issue sort of fails to acknowledge that sexual harassment is a form of discrimination that goes far beyond the workplace. In our view, there needs to be a much wider, holistic approach from an anti-discrimination perspective to stamp it out, not just a safety perspective. Over to you, Georgia.
Thanks, Steve. So we'll move into the changes to the Fair Work Act first. And initially, when you first have a look at them, they do appear quite minor. When you understand the application of the Act and how many things it does govern in our day-to-day lives and in our work, these changes don't seem to have huge impact to us as employers, but it's really important that we understand them and that they're reflected in our workplace policies. I think it'll take some time for us to understand the overall effectiveness of these changes as well. So I think we'll all have to stay attentive to any further legislative changes or interpretations by the government or by the Ombudsman relating to these changes specifically. The most notable change was the introduction of the Fair Work Commission's ability to issue stop sexual harassment orders. So that phrase, stop something orders, might sound familiar because there's a very similar process that currently exists for bullying called stop bullying orders. It's a very underused part of the Fair Work Commission, and in the 2020 to 2021 year, there were only 782 stop bullying applications brought before the Fair Work Commission. To contrast this, in that same time frame, there were over 13,280 unfair dismissal applications. So it's very under accessed, and a big part of that is because through this particular process, there are no damages awarded. And in most cases, if employers have already met their obligations under existing safety and workplace legislation, harassment and bullying matters are likely to have been resolved at the workplace level. So the introduction of this process doesn't seem to have made much of a difference, but it does allow employees an alternative avenue to seek support if they don't believe their workplace is doing enough to following the report of a sexual harassment. And it is a low-cost alternative. So the employees just have to pay an application fee, and from there, they'll have the support of the Fair Work Commission. This change obviously came in at the time that the legislative changes did in late September 2021, but there was a delayed implementation while the Fair Work Commission had to put its processes and procedures in place to figure out how this process would look internally. But it is now in full effect, and the Fair Work Commission has had its first case go before it. And so for the Fair Work Commission to issue orders in this particular process, they need to be convinced that the subject of harassment remains exposed to further harassment. So they need to identify that the harassment is continuing to exist and that the person who has brought these allegations forward will continue to suffer detriment or be subject to the ongoing harassment moving forward. In the first case that was brought under these new powers, the Fair Work Commission decided not to issue orders to stop sexual harassment on the basis that it would be unlikely that further harassment would continue for the person that brought forward the application. So we're going to have to wait and see, I guess, how this process will benefit employees and what kinds of matters are brought forward. But I think it's an interesting addition to the Fair Work Commission's powers, and we'll have to see what kind of cases that do come up, and if there are ones of interest, we'll make sure that we bring them to your attention. The next change to the Fair Work Act was that sexual harassment has been added to the list of confirmed forms of serious misconduct under the Fair Work regulations. Again, in most cases, most of you probably thought sexual harassment was a form of serious misconduct and it would be a permissible reason for termination in most cases. So this isn't a huge change, but it just makes it expressly clear that sexual harassment is a form of serious misconduct if substantiated, and termination is a suitable outcome in those processes. To support the above, we've also had a definition of sexual harassment inserted into the Fair Work Act, and that's just to assist with clarifying which behaviours do constitute harassment. This isn't a new definition. It does mirror the definition of sexual harassment in other forms of legislation. However, it may be useful to have a look at this definition and make sure that the definitions included in your training materials and your workplace policies is consistent with the definition that's available in the Fair Work Act and other forms of workplace legislation. I'll move into the Sex Discrimination Act changes. So Steve and Mary have both touched on some of these changes, but we'll go into them in slightly more detail. So the key change to the Sex Discrimination Act included an increase to coverage provisions. So this act now covers members of parliament, judges and public servants, where previously they were exempt from coverage. And that's really important because it does provide some key protections to these individuals that previously weren't able to access them. The coverage provisions for private sector employers have also been extended, as Steve touched on the definition of a worker when we discussed safety. That definition has now been brought into the Sex Discrimination Act. So the Act now applies, the application goes beyond paid staff to also cover your volunteers, interns, apprentices, unpaid workers, and self-employed persons that do interact with your business. So that is a big change. It's likely many of you had the assumption that they were already covered by your policies or by these forms of legislation, but this just makes it explicitly clear that they now are, and you may need to update policies and procedures to reflect that. We are likely to see additional changes to legislation that mirror these extended forms of coverage. There's additional, Parliament is dealing with some of the other recommendations. So there were 12 that were ultimately put forward, legislative changes. We've only adopted 6. Some of the remaining 6 do cover extended provisions for members of Parliament and people who do meet the definition of worker. So we are likely to see some further changes through this process and to the application of not just this piece of legislation, but the other ones discussed in this presentation as well. But we'll just have to see how that progresses as the year goes on. We also need to acknowledge that under this Sex Discrimination Act, that we now have sex-based harassment as a recognised form of harassment. So it's separated out from sexual harassment, and we're discussing sex-based harassment. And sex-based harassment is defined as unwelcome conduct of seriously demeaning nature by reason of the person's sex in circumstances where reasonable persons would have anticipated that the harassed would feel offended, humiliated, or intimidated. And I'll give you some examples of what sex-based harassment could include. But essentially, it's a blanket term to cover behaviours that could be considered sexist, misogynistic, or misandrous. So that extends to offensive comments or requests, whether verbal or in writing, and other forms of conduct that would not be tolerated in those kinds of settings. But the conduct, for it to be covered by the legislation, does have to be serious. So mild conduct, it doesn't quite extend to, but I think that's a really big change, and we'll have to reflect how workplace policies and procedures do cover this, because sexist comments, misogynistic behaviours, they do need to be addressed. It's likely they already are and captured under things like your code of conduct and those other forms of policies. But we do need to make sure that they are expressly covered as their own unique form of harassment, and that they are included under this form of legislation. The last change we'll cover in relation to the Sex Discrimination Act is the ancillary or accessorial liability provisions have now been extended. This is a pretty big change for employers because previously people couldn't be held liable for aiding or permitting sexual harassment in the workplace. So the harasser themselves could be held liable, but people who aided that behaviour, they weren't protected. But now persons who cause, instruct, induce, aid or permit sexual harassment and sex-based harassment may be personally held liable. That means that managers and executives may be exposed to liability for failing to take adequate steps to prevent or respond to workplace sexual harassment, or in situations where there was a possibility of it occurring. And whilst this isn't quite a positive duty, which Steve has touched on quite heavily, it does make possible liability for aiding or permitting sexual harassment possible. So turning a blind eye will now have legal implications for employers. So we need to make sure that there's a culture that's built around if you see something, you speak up about it, because otherwise that could be a form of aiding sexual harassment within the workplace, and it could be quite dire for the individual. We'll move on to the final legislative change that came out of those 6 recommendations that were adopted. And this relates to the Australian Human Rights Commission Act. And these changes, again, weren't huge, but it does introduce better protections for people who report instances of sexual harassment to the Australian Human Rights Commission. And what this means is that people who are threatened or subject to detriment as a result of reporting these behaviours or making a complaint to the Australian Human Rights Commission can now pursue civil and criminal proceedings under the Act. So there are additional protections there. There is also an extension of time. So the individuals will now, it used to be a 6-month period in which they could report to the Australian Human Rights Commission, and that's been extended to 24 months. So there's a considerable extension of time there. I think we can all account for these conversations are difficult to have, and reporting them is likely to be a much more difficult process for the individual as well. So that extension of time will be quite a benefit to those who do choose to bring their matters before the Australian Human Rights Commission. And I'll pass back to Steve now, and he can take us through what changes we need to make to implement the legislative requirements.
And thanks, Georgia, for covering off on what changes, specific changes were made to the legislation, as you've just indicated. Okay, so that's what's happened in the legislation. What do we have to do to make an impact here? Many people, including many women, are loath to seek to apply special treatment to disadvantaged groups. And I think Pauline Hansard from One Nation sort of tried to pick up that. She railed against creating a victim culture as a reason for her to support, or her party to support, the federal government's opposition to creating a positive onus on employers, or for employers, to prevent sexual harassment in the workplace. But who can argue with the principle that all people deserve respect and fair treatment? It's a bit hard to say, well, it's okay to harass people, because everyone should get respect and fair treatment. So in a modern productive workplace, why should harassment in any form exist at all? The fact that sexual harassment and even sexual assault in some cases has had such recent media attention probably reflects that the whole area hasn't had the same attention as other forms of discrimination or misconduct in the past, or it hasn't had the attention it deserved. So now everyone is looking, what should employers do? And whether we treat it as just a workplace health and safety matter, because that's what legislation certainly applies to it, or whether we're trying to take a much wider approach of achieving a fair, productive workplace for all people coming in contact with a business, well, then you're going to need certain minimum actions to be put in place. And in that respect, I just want to touch upon the Australian Human Rights Commission's National Awareness Raising Strategy, Know Where the Line Is, which is a tripartite partnership between the Australian Human Rights Commission, the ACTU, the peak body for unions, and also the Australian Chamber of Commerce and Industry, which is a peak employer organisation. And under that strategy, there are 3 elements. The first one is to see, if you know where that you should know where the line is. You should draw the line and say that's bad behaviour. If you see something or hear something that makes you feel uncomfortable, you shouldn't ignore it. The second aspect is talk. It takes courage to speak up. People need to talk with their bosses, their colleagues, or with persons who are crossing the line. And thirdly, offering support. Don't underestimate the power of support. It can help a colleague stand up and take action. So the thing with the Know Where the Line is strategy, it establishes a firm understanding of what constitutes unacceptable conduct and behaviour. And by establishing the necessary standard, let's hope more people will take action when they see or hear of behaviour that crosses the line. Because the fact is that many people who experience sexual harassment don't even report it. And many don't even recognise that unwelcome sexual behaviour at work is against the law. So that's why it's necessary to have clear delineation of what standards are and how they're going to be enforced. So what else should employers be doing? Look, it's just not going to be enough to put up posters, maybe run a staff training session, or make it part of induction training for new hires. But if you start to combine all 3, plus you reinforce your standing or your standards around sexual harassment and sex-based discrimination in staff handbooks, you make it part of a regular staff updates, maybe you're starting to get there. So it's going to be a whole range of different policies you need to be putting in place. So making it a living part of your company or your brand culture starts to embed it permanently in your organization and gets beyond just a safety approach and gets into that anti-discrimination approach. Even an idea here is, what about surveying your people as a start to assess your current state of play? Now, what is the risk in your workplace from harassment? So perhaps getting that data by surveying your people, putting it on their agenda as well, by making it clear that, well, you're interested in it and you're asking them, what do they think about harassment in the workplace? Is it happening? You also want to make training specific. Give clear examples of what's acceptable behaviour, what's unacceptable behaviour. People need to know there's a line you cannot cross. They need to understand what that line is. So only by educating people, by giving specific examples, will people start to understand where they must draw that line and what is acceptable behaviour or not. Now, there's plenty of existing training materials and videos out there to help embed the message. Even on the special, there's a special Australian Human Rights Commission website that's set up for this Know Where the Line Is strategy. So just Google Know Where the Line Is. You'll find that website on the first page of Google, and then you can go onto that site and you'll find a whole lot of video resources that have been created to help organisations to establish clear guidance on how to deal with things like sexual harassment. Next thing I've already got up on the screen there is having a clear policy. And we've got ER Strategies, we developed a code of conduct years ago. It's not just about sexual harassment or not just about employee grievances or whatever else. It's about a whole range of things that a whole range of policies that employers often have. And because you might have a sexual harassment policy, you might have a victimization policy, you might have, you've got all these different policies, and it can get a little bit confusing for people about, well, how does all this fit together? So maybe instead of just having all these separate policies, try to bring them together into a clear code of conduct and maybe call it respect at work, because every employee should be respected at work and every employee should be offering other employees at work respect as well. It's just a way, I guess, of simplifying things, bring it all together under this respect at work. Shouldn't just be about sexual harassment, but respecting employees in all aspects of relationships and what features they may have as different people. And that way you can unify a lot of the different processes you might have. Like somebody might have an issue that, okay, if it was a safety issue, they had to do it this way. If it was a harassment issue, they had to do it that way, or whatever else, you might be able to unify a lot of those processes. Another issue is that you want to have clear reporting lines. And so therefore your policy should make clear what should happen if there is a complaint or somebody has a complaint, what the process is for raising that complaint. But even then, what happens to the complaint afterwards? Often companies, unfortunately, don't act decisively. They might be investigating a harassment complaint and might roll on for months because they're just not familiar with it. So maybe you need some external expertise to come in, investigators who do this stuff all the time. And I can think of a number of people out there that we recommend for companies to use when they have a sexual harassment or other sort of harassment complaint. So you want to make sure these things get dealt with decisively. Don't let it just roll on. Have a plan, stick to that plan, and take decisive action. We need to recognise the impact of harassment on employees in our workplace, that we're not going to accept it, and therefore we're going to take decisive action where it's uncovered. And it won't be a surprise to people because you would have had the clear policies, you would have had the education to all your employees, the clear guidance materials and everything else to make clear that harassment is not going to be tolerated in your workplace. Over to you, Georgia.
Perfect, thank you. And so we just wanted to end the presentation on some really key quotes from the Sex Discrimination Commissioner, Kate Jenkins, because this sums up the presentation. This will sum up the policies, the training, all the different things that you put in place within your workplace. Sexual harassment is not a women's issue. It's a societal issue which every Australian and every Australian workplace can contribute to addressing. Workplace sexual harassment is not inevitable, it is not acceptable, and it is preventable. And that's how we hope you leave this presentation.
Can you talk us through the main recommendations arising from the Jenkins report and where they are up to in the legislative agenda?
Absolutely. So the key changes that we've seen were the changes that were really going to impact employers at that kind of private sector level. We will see additional changes to adoptions of the application to the Fair Work Act changes. So that was the stop sexual harassment orders, the insertion of the definition, and it being classified as a form of serious misconduct. Parliament is considering whether those extensions will be brought over to public sector employers as well, or Parliament, public servants, those people in those forms of professions. Because currently they aren't governed by the same forms of legislation that private sector staff are. So that's one aspect that they're considering moving forward. In terms of sex-based harassment and the Sex Discrimination Act, as far as I have been across, there aren't many additional changes there beyond that extension of the definitions and the application to Parliament, to judges and to their staff. And for the Australian Human Rights Commission, the reporting periods and the charges that can be, the processes that can be taken through that, that application does extend already. So we aren't likely to see many more changes from the remaining recommendations, but it'll be more so the application of the existing ones that have been put through. The only other big one would be that the Labor government is very much supporting the introduction of that positive duty, that positive onus on employers to prevent sexual harassment at the federal level. There was a lot of talk about it in Canberra last week with Grace Tame and Brittany Higgins at the Press Club really pushing for that. So it'll be interesting to see whether that progresses and whether we do see that, that obligation imposed on employers. But at this point in time, it's just a bit of a waiting game.
What are employers' responsibilities relating to respect at work when it comes to contractors and externally employed employees?
Basically, the employer, or the PCBU, the fancy term, owes a duty to ensure that the health and safety of everyone coming in contact with the business, even customers. So whilst they might not have the same degree of control over the contractor, they still have a duty in relation to their own employees to ensure that other people aren't harassing their staff members. So they need to be taking steps when they're engaging contractors to make sure there's appropriate processes in place on the contractor's part to make sure that there's not going to be poor or bad behaviour by their people to the employees of the business or even to the customer. Yeah.
How does respect at work legislation impact franchise businesses?
In terms of safety legislation, even if we just leave it as a safety thing rather than anti-discrimination approach, that the franchisor does have a duty to liaise and consult with other duty holders who have also a duty of safety. So this does give you the obligation as well as the right to talk to your franchisees about these things, making sure that they've got policies in place. And perhaps, I'm sure they'll be looking to the franchisor in many cases for that support. If we can be working on putting together packages of training, of policies, of processes to follow, perhaps surveys to carry out. There's a whole lot we can be doing as franchisors and franchisees to make sure that sexual harassment, sex-based discrimination is given the boot.